Good morning, everybody, and thank you for joining us this morning for our webinar on SCARP Practical Issues. I'm Laura Michelle Moore, and I'm a Technical Manager within the Professional Accountancy team here at Chartered Accountants Ireland. I have a keen interest in this rescue process, having worked myself in insolvency for many years, and I would like to welcome our guest speakers, David Swinburne and Philip Maher of Mazars this morning. Both David and Philip have many years of experience in the corporate insolvency sector and have extensive experience in both formal and informal financial restructurings. David and Philip will now take us through some practical aspects of the SCARP process and are happy to answer your questions during the session. So please feel free to send on any questions on the Q&A function and we'll answer as many as you can. I'm now going to hand you over to David and Philip, and I'll see you after the session. Thank you very much.
Good morning, everyone, and thank you, Laura Michelle, for that introduction. I'm delighted that so many people have registered for this morning, which just goes to show the level of interest that is in SCARP. I suppose one thing we are finding is that there's still, I suppose, a lack of awareness and knowledge of SCARP. So hopefully this morning we'll be able to chat through some of the practicalities around SCARP. What we propose to do is sort of have a dialogue Q&A session between myself and Philip, as opposed to having a heavy slide deck free and going through the legislation, but have a more focus on the practical elements of SCARP. And like Laura Michelle outlined there, please do, if you have any questions, queries, please put them into the chat or indeed the Q&A button, and we will ask them, because we find the participants get more out of these sessions by asking questions. And I've no doubt that you've all come today with questions, and I suppose that's the whole purpose of this session, is to answer questions and practical questions. So we're happy to take them all. I suppose SCARP has been around for a little while now, 2.5 years. It came in December 2021, and the reason for introducing it in the first place was as an alternative to an examinership process, which was seen as being very costly. So the SCARP process very much mirrors examinership, with a couple of key differences. One being under SCARP, you don't have to go to court, so the court is not involved at the outset. So that makes it much easier, and because there's less court involvement and less legal involvement, the overall costs in the process are much lower than examinership. So it's very much akin to examinership, and the examinership process has been around, as we all know, for over 30 years, and it in itself has been successful. So therefore, I've no doubt SCARP will be successful. The time frame is also shorter than examinership. It's 49 days as opposed to 100 under examinership. And again, it's all about viability and saving enterprise and companies. I suppose the eligibility requirements in order for a company to enter SCARP has to meet 2 out of 3. So turnover must not exceed 12 million. Balance sheet not exceed 6 million, or employees be not more than 50. So that's quite large and actually captures 90% of entities in the country. So in theory, SCARP is open to 98% of companies in the country, should it need to avail of SCARP. So that's just a brief overview and introduction to it. To date, we've had 62 cases, which is the number is very low. And again, at the outset, I think our view would people are still not very familiar with the process or are fully aware of it. Despite the numbers being low, I suppose we haven't been in an area of enforcement for the last couple of years, and we would see insolvencies rise, and they are starting to rise a bit when enforcement. So when somebody takes action, when a creditor takes action against a company, or creditors start to take action, and indeed one of the biggest creditor in any insolvency is normally the revenue. And to be fair to them, they haven't been overly active in the last number of years post the pandemic, because we're all very well, they had the debt warehouse scheme. So a lot of debt got caught and captured in that, and people will be well aware from the first 5 months of this year where they have been reaching out to companies that have warehouse debt to put an arrangement in place in terms of dealing with that debt. So that deadline has passed now, and it will be interesting to see as time goes on, will the revenue become active and start to do enforcement? If they do, there will be no doubt there will be an increase in the numbers. Of the 62 to date, 44% of those have been approved, so that's over 70%. So I think that in itself does confirm that this process does work. 12 schemes failed and went into liquidation, and of the there's 4 ongoing schemes, and then another 2 schemes. One came out of the SCARP process but did an informal arrangement. So I suppose that's another success. You could say they did come out of SCARP, and then there is another case that started out in SCARP and now is in examinership. And we'll talk a little bit more as time goes on as to why a SCARP may become an examinership. But I think in overall terms of the 44 plus the 4 ongoing, and hopefully they will be successful, and the one that has had an informal scheme. And again, too, we find as well over the last number of years that while the number of insolvencies, and particularly around SCARPs, haven't been huge, we find that an awful lot of issues around companies on the verge of insolvency can be resolved through informal schemes of arrangement, because the whole point of having a scheme like this is to save enterprise, to save jobs, to have the entity continue to trade. That can actually be worked out via an informal scheme as opposed to a formal scheme. So again, we find if companies come and engage early, and we can look at the issues that they do have, that they can actually work out an informal scheme without actually having to go through a process. So I think that's another benefit and something to be aware of, that you don't necessarily have to go through a formal process of a SCARP or an examinership. So I think that's just a brief overview of SCARP to date and where we're at.
Thanks, David, for that. And good morning, everybody. Philip Maher is my name from Mazars. So even just to pick up, David, on those 62 cases that you mentioned and the good success rate that's there, Mazars have been involved in 2 of those SCARP cases, and we're also involved in the first SCARP in the country. So have that distinction. But I guess for our audience, David, out there this morning, maybe they want to know how a business can prepare for SCARP. So I suppose in terms of the process, what are the key things? What are the key requirements that a business needs to be aware of?
I think the key thing and the overriding thing is to engage early, and that's been coming up all the time. So it's never too early to engage in terms of looking at SCARP, right? Because the key thing here is about viability and saving enterprise. So you need to have a look and see this company isn't in a good place at the moment, i.e. it has got too much debt on its balance sheet. So just let's park that for the moment. But it's very much looking to the future enterprise. Does it have a good core, solid underlying business that is worth saving? Because we're looking at either, the whole or part of an undertaking. So it's very much looking to the future, and is there a good core profitable business there worth saving? If so, well then yes, you should definitely consider SCARP. Before going into the process, you need to have all your financial information up to date, so you can have a look at the balance sheet needs to be up to date, so you can have a look at the overall profile and type of debt that's in the balance sheet. And again, looking to the future in terms of the projections, challenging them, how robust they are, and those projections actually turning into cash. So if there is a good core viable business there, it should definitely consider looking at SCARP in terms of dealing with the debt that's actually holding it back from going into the future. Financial information being up to date is absolutely key, because the process advisor, before a SCARP actually starts, has to have a look at the overall profile of the debt and the mix of that type of debt to work out whether or not it would be suitable for SCARP, or is it potentially too complex and potentially should be looking to do an examinership instead. And again, too, I mentioned there in the intro about the revenue being the biggest creditor, so ensuring that you're compliant with the revenue, all returns are up to date, you have a good working relationship with not only the revenue but all your creditors, because they are key stakeholders in it. So never too early to engage. Is there a core profitable, viable business there that's worth saving? Financial information up to date, and I think that's really key starting point to look at all of that.
Yeah, I think in addition as well, in terms of the criteria, a company must be unable or likely to be unable to pay its debts. So insolvent or technically will be insolvent. There must also be no resolution or order to wind it up, and it must not have been in examinership in the previous 5 years. So that, I think the key test is around the insolvency piece, that they're technically insolvent, but that the other side of that, David, is that they have a reasonable prospect of survival, that the business is fundamentally viable into the future. So it's the two sides of that piece. One is that now, whether it's due to a one-off event or something has happened, that they're insolvent and are struggling to pay their debts as they fall due. And then the other side of it is that, well, fundamentally, that there's a business model that is sound, and with some restructuring will be sound going forward and will be viable. So yeah, just I suppose
and so just on
Yeah.
that point there too, Philip, sometimes company, you're absolutely spot on. It needs to be technically insolvent but on the verge of insolvency. So going back to the point of engaging early, a company can be insolvent on a balance sheet basis for a considerable period of time, not recommended, because if that's the case, it needs to be looked at. But cash, it's all about cash. Cash is king. So if you run out of cash, you run out of road and you will not be able to go into SCARP. So that's why come back to the early engagement point, and can't overemphasize that enough, because it's very much about looking at the cash and preserving the cash. Because again, in this process, the company continues to trade, and it can only trade if it has cash. So in terms of, don't be waiting to run out of cash and become insolvent. You're under way too much pressure, and then the prospects of SCARP being successful, I suppose, again, is fundamental. Again, in terms of the early engagement, looking at this, the business may not be viable. So if the business fundamentally is not viable, well, then SCARP is not for it. It probably does need to be wound up. So again, to that early engagement piece, to have a look and see around the viability piece, because that is key. And if it is not viable and, historically hasn't made profits, and the projections are showing that it won't make profit, well, then maybe the hard decision does have to be made just to wind it up and not enter the SCARP process, because, it's just not suitable.
Yeah. And you mentioned if it's not viable, liquidation will follow. I suppose that's one of the disadvantages of the SCARP process. If you go through it and it doesn't work out, well, it's very likely that liquidation will follow. So it might be useful, David, if you give an overview as to some more of the disadvantages, but also what are the advantages of SCARP?
Yeah, I suppose in terms of some of the key advantages, like the company does continue to trade, it's saving enterprise, it's saving jobs, and fundamentally that's really why it was introduced. It is designed then in terms of the balance sheet to restructure that. So you're looking to preserve the value that's in your assets, be they tangible or intangible assets. And then on the liability side, you're looking to restructure, write down that debt. So fundamentally going forward, the balance sheet is solvent and starts in a good footing, It will have to provide a better alternative to the creditors than liquidation. So the return that they're going to get on SCARP needs to be much better than they would get on liquidation. And again, very often you find for creditors, while they are being burnt, they are being crammed down, they are losing out. Traditionally, they've had a long-standing relationship with the company, and they will have made profits from them over the years. They'll want the company to continue because they want that business themselves in terms of looking at the potential, the future viability of their own business. So creditors just, while they're being crammed down and their debt's been written down, and nobody ever wants that, the alternative will be better than liquidation, plus they will have a future trading partner going forward. Again, the time frame, the 49 days at a minimum versus the 100 under examinership. It can deal with some complex creditors like leases, which we'll talk a bit more about. And it is less expensive with an examinership. I suppose some disadvantages, and you outlined it, if it doesn't work, well, then the alternative is liquidation and or receivership if there's secured debt there, Creditors potentially could object to it, but again, to the early engagement piece, if you have them on side and bring them on a journey, there's less prospect that happen. But that is a potential disadvantage. A creditor can object, and if they do, then it leads to a little bit more complication. And during the process, the company does have to let all its trading partners and those that work with know that it is in the SCARP process, and has to let that be known prominently on its website and interaction. So that potentially could have a negative impact, on its relationship with customers in particular. But again, if you can come back to the early engagement piece, you can work through all these and see who needs to be engaged with to ensure that that doesn't happen, or that is minimised at a minimum, and I suppose the other thing there is that, and we will talk about, there is the concept of excludable debt here. So that's something that, is here that's not an examinership. So potentially that's something that might cause a little bit of a wobble. But again, we'll talk a little bit more of that. But I think in overall terms, I do think the advantages of the process do very much far outweigh any of the disadvantages.
Yeah, absolutely. And I think you mentioned in terms of the advice accountants in practice should give to their clients about the process. I think one of the key things that's come across already in what you've said is that early engagement and detailed planning as well is critical. Making sure that you've looked at all these matters and you've consulted deeply with the business owner and you're aware of also as well as a consideration is just not only the micro factors of what the company, the SME is going through, but also the macro factors in terms of the general economic environment and other matters like that you need to provide advice for. So is there anything else, David, in terms of that immediate advice accountants need to give?
No, I think it's very much sitting down, looking at that, starting to do the projections, because we all know it takes a while to get those fine-tuned. So start the projections as early as you can, look at the assumptions, challenge the assumptions, and see how those projections flow in through to cash flow to work out, ultimately, is there a funding requirement here, which there will be, and then we'll talk a little bit about funding later on, but then looking at, so it's the early engaging piece to say, there is a viable business here, there is a cash requirement, a funding requirement, what's that? So the earlier that whole process starts, the better, I suppose just looking there to touch in terms of creditors, like creditors are obviously the key stakeholders, or one of the key stakeholders in all this process, Philip. So I suppose just in general terms, you might talk about how a company might deal with the creditors either before the process, during the process, and what a creditor could potentially do to scupper the whole SCARP process.
Yeah, so I guess a couple of key points in terms of creditors is that, and I think there's a question that's come in around the excludable creditors. So that's good timing really, and in terms of excludable creditors, if we start with them first, David, that's revenue and other state creditors who have the ability not to participate in the process. So I'll talk about them in a minute. I suppose in terms of the general creditors, you want, as both the process advisor and the company proprietor, you want to have the majority of your creditors on board. You want to make sure that there's open and transparent dialogue with them. I think one of the key points to note is that you outline the benefits to the creditor of going down through this process and what's in it for them really. And really, I think when you weigh up what the position would be in liquidation vis-a-vis what the position would be in the proposed SCARP process and dividend arrangement, then it'll be clear to them that the outcome is better for them in the SCARP process than in a liquidation, and also you'll have a trading entity continuing into the future, which is the most important factor. So, in general, to answer the question that's come in, the attitude of excludable creditors, I think you may have referenced it, from revenue's perspective, is that they've generally been supportive of the process, supportive of practitioners who are going through the process. That's not to say that they don't go through it with a fine tooth comb. And if I could share my experience from the first case to, I don't think it's quite the last one, but certainly in the last number of months, the level of detail that the revenue have looked for has increased significantly on that. So, but I think if you can not convince them, but you demonstrate to them by way of the advisor report and the cash flow projections that you mentioned, David, and the workings, and ultimately that the business has a reasonable prospect of survival, then you answer their questions and they're supportive of it. And just to note that they have 14 days to decide whether they want to opt out of the process or not, and they need to give their notice to the PA on that point.
Yeah, and I think that's an interesting one too, that I think sometimes when people think of the excludable creditors that they're automatically excluded, but like I said, they have the 14 days in which they need to let the process advisors know why they want to be excluded, so they have to have solid grounds as to why they want to be excluded, as opposed to, oh, we just don't want to be taken part of it. But I think you're right. And again, to those that have interacted with the revenue over the last 5 months in relation to the debt warehousing will know that by and large, yes, they have been supportive and they want to be supportive. And I suppose historically, revenue have always been supportive of schemes, be they in examinerships or SCARPs. Like you said, they're going to do their due diligence and stuff like that. But they are inclined, unless, and okay, each case is different, but by and large, they are very much inclined to be very supportive of schemes and not look to be excluded, and obviously partake in it. I suppose just on I see just another questions popped in there just around creditors as well, and the attitude of banks in relation to either their unsecured or indeed their secured debt.
Yeah, so in my experience in terms of the banks, they were not impacted by the SCARP process, and they didn't have any impairment in terms of their security. So once they got that comfort that it didn't have any impact on them, that that they were fine. And I didn't come across a case with unsecured debt, but if it is unsecured debt, you need to take a look as to whether there's any the personal guarantees maybe associated with it. But an unsecured debt would rank similar to the other unsecured debt and trade creditors, who would be, I suppose, brought into the scheme and brought into the pot, and depending on the level of investment and the level of the dividend that's required, you determine what amount they're going to be paid. So in general, the attitude has been that if the bank security is not being impaired, then I suppose they're okay with it in theory. But they obviously want to see that the business continues, and that's been my experience. I don't know if there's anything else, David, you want to add.
No, I think that's spot on. Yeah, no, absolutely. At the end of the day, once their security has not been prejudiced, and like that, the scheme deals with all creditors, and again, to the early engagement piece, looking at the profile of the creditors. So if there are secured creditors in the bank in there, they need to be engaged with early on, to let them know what's happening. You need to deal with them and have them worked into the scheme, even if that means a restructure of the debt, not necessarily a write down, because if the bank security far outweighs the value of the debt, well then potentially they might need to be restructuring there in terms of extending the term or something like that to make it work from a cash flow perspective. But by and large, again, absolute support. But again, come back to engaging with the early. They don't want any surprises, because again, we all know from dealing with banks, they have their own internal processes to go through, and that can take time. An interesting thing that just popped up that's coming to my head when you mentioned there about personal guarantees, Philip, and I suppose that does come up, and it is very important that if a principal, usually a director or shareholder, has personally guaranteed debt in respect of a creditor, and that creditor gets notification from a process advisor in relation to voting for a SCARP scheme, that creditor must, within 48 hours, pass that entitlement stroke right to vote, and if it doesn't, it could very well lose its ability to enforce the personal guarantee. And the key thing to remember is 48 hours. So if a notice of a meeting was sent out on a Friday evening at 5, the time runs out at 5 on Sunday evening. So it's just very important that if a creditor gets notice of a SCARP creditors meeting, and there's a personal guarantee involved, it passes that vote on to the creditor within those 48 hours. So it's just interesting. Again, too, the benefit, I think, of this is questions coming up because other things come out. So it's great to see the questions coming through.
Yeah.
And if there's others, please do send them through.
Yeah, no, there's while we're talking about creditors, there is a couple of other ones. And I think the first one I've addressed, but it talks about how much detail do they require in relation to the business plan. And I'd say on that, a significant amount of detail. You really have to outline in the process advisor's report, the background, the detail, what are the conditions that are essential for the survival of the company. And as David said, the cash flow projections, and really setting it out. The useful thing I'd say is that the legislation there is helpful in setting out what exactly is required. and what needs to go into the business plan. So that should be of benefit to you. And then there's another question there, David, around state creditors with excludable debt. Sorry, other state creditors with excludable debt. So in that instance, you're talking about the likes of the county council rates and such, and whether they can stay outside the process. But the legislation is very confusing because their entitlement to do so relies on conditions which are entirely related to the Collector General revenue matters, including aspects of which they should have no information. In reality, can they ever stay outside the process? What I'd say on that is, in practice, they're I haven't yet to see them exclude themselves from the process. But I take your point, and that is quite confusing. All right.
Yeah, and I suppose the key thing there is if there is an excludable debt outside the revenue, some other maybe somebody had an award for unfair dismissal or something like that, and that needs to be dealt with in the scheme. Now, if it's it needs to be dealt with whether it's inside the scheme or outside the scheme, and if it can't be dealt with, well, then that's where you could run into difficulty in relation to SCARP. I may have to consider then going down something like an examinership to actually deal with it. So I suppose the overall overriding point, whether it's dealt with outside the scheme or inside the scheme, I suppose it needs to be dealt with holistically as part of the scheme, because if there's, otherwise it brings uncertainty. And if there isn't, in terms of whatever the level of debt is, if it can't be dealt with, well, then fundamentally it puts the overall scheme at risk. So it needs to be dealt with either inside the scheme or outside the scheme. I don't know if that answered the question fully or not. If not, come back to us.
Yeah.
I suppose just there when we are, I just touched on employees, and the employees may very well technically be creditors at the time you go into the SCARP process, but again, they're obviously key to the business continuing to trade and survive. So very often, the employees under the legislation do have to be informed of and be part of and fully aware of what's going on in relation to the SCARP. Very often, any of their entitlements are never written down, because they're key to the process. If they do have, holiday pay and arrears of wages and all that sort of good stuff, it never gets written down. So just something to bear in mind that other than, I said, you might very well have something like where there could be some unfair dismissals or Labour Relation Commission claims or something like that, which could be sizable and indeed could be one of the reasons why the company's not able to potentially pay that, and maybe one of the reasons why it is looking to go into SCARP, or one of the reasons why it may become insolvent anyway. And that's usually the case of former employees, if there was some claim out there.
And maybe, David, just in terms of, you mentioned that that there's no court process, and I think that was one of the main thrusts of the legislation, was to reduce the cost of the whole process. But I suppose, to what extent is the solicitor involved in the SCARP?
Yeah, you're right. There's no automatic sort of requirement for the involvement, because you're not going to court for protection and all that sort of good stuff. So therefore, there's no. But I suppose in practical terms, you may very well have some legal advice required throughout the process, particularly if something nuanced comes up that you want to get a view on. So while expressly there's no requirement for a solicitor, I think in practical terms, and what we've seen so far, there is involvement. And if there has been involvement of a solicitor in relation to the process, from the process advisor's perspective, the cost of that become a cost of the process as well, obviously. But while there's no express requirement for them, they can be there, and it's not that you can't use a solicitor. Again, too, we know from our experience of working in the areas of insolvency, in all cases, various things popped up that nobody had envisaged. So in terms of working through them and how to deal with them, and in terms of creditors, and you have different classes of creditor, and potentially if you think a certain class of creditor might have a different right or entitlement to another, that's where you might very well need some legal advice in relation to that. So while there's no express requirement for them, In practice, yes, you do have legal advice, albeit it's not as heavy and as would be an examinership. I suppose just on that point, questions come in there around protection and safeguards during the SCARP process for creditors. So it is very different to examinership. In examinership, the company's under gets court protection, so no creditor can actually take action. This is not the case in a SCARP process. So in a SCARP process and during the process, a creditor could take action, so could seek to petition to wind up the company, or indeed a secured creditor could seek to appoint a receiver, so that there's no protection from that happening. Again, and we touched on a little bit, if there is secured creditor debt, they'll have to be dealt with, and you'll want to engage them, and so you hope they wouldn't need to do that, because you are engaging with them and you are working through with them, and that shouldn't happen. But just there is no formal safeguard or protection.
And then there's then another question. We spoke about the personal guarantees and the personal liabilities as such of directors. So the question that's come in about any experience from the perspective of directors where the revenue is entitled to pursue them, their personal PAYE has not been paid due to the inability of the company to do so. So we'd obviously see this a good bit in liquidations, and it's something that the revenue are still very much active on. But David, I don't know, do you have any
yeah, no, and that's a very good. No, absolutely, and it's a super question, and it's one that's coming up again and again and again too. It could very well be one of the reasons why we haven't potentially seen as many examinerships or sorry, SCARPs as we have, because yes, that is so that personal that liability for the director's PAYE does become their personal liability, so it does need to be dealt with. So yes, that's something for advisors on the call here to be very mindful of, because that can't be dealt with within the scheme. So if there is if that is there, yes, outside of the scheme, the directors personally will have to come to an arrangement with the revenue in terms of dealing with that. It's nearly a bit of akin to like a personal guarantee in some ways to the revenue. But yet, no, that has to be dealt with by the directors outside of the scheme. Again, to come back to the early engagement piece, if that is there, if it is a sizable debt, that's something the directors need to work out how they're going to deal with that, post a SCARP, if depending on what it looks like potentially that number is going to be for them. But yeah, they are entitled to pursue the revenue, and I think they will be doing that. So it is very much something to be borne in mind, and a very key factor. Yeah, absolutely, a good question.
Okay. One thing actually we mentioned, but probably didn't go into in much detail, was the onerous contracts and onerous leases. I guess the key point to mention is that onerous leases can be repudiated with the consent of the creditor. If no consent is provided and repudiation is necessary for the plan, then it does require an application to court. So I suppose that's where the court aspect is provided for in the legislation, and potentially can come in, and so it's there as a backstop. But I guess what you want, and similar to involvement and engagement with other creditors, is to engage with your landlord and try to resolve any issues with them in a kind of consensual basis. But the fail-safe for that is you can potentially go to court to get an onerous lease repudiated.
Yeah, and I suppose that's again, to this, it's envisaged for it not to be a court process, but I suppose there is, could I use the word comfort, that if needed you can go to court. I suppose that's just one of the good fallbacks there, that if you do come across something in the process that yes, there is some onerous contract or lease that everybody's tried to resolve to the best of their ability, and for whatever reason it hasn't happened, or indeed there could be some other claim or a contingent claim or otherwise that arises and it can't be dealt with. I suppose it is just good to know that the comfort that you can make an application to court in relation to that. But ideally, in terms of the SCARP process and the early engagement, you hope you'll be able to look at that and come to a resolution and have them bought in and consent to. Certain creditors, particularly large landlord creditors, may not want to be seen to be consenting under SCARP, so that could be difficulty for them. So again, going back to the early engagement point, looking at the profile of your creditors, so that could be a key decision as to whether or not you're going to do SCARP as opposed to examinership, because potentially certain creditors, a bit like banks, may not want to be seen to be conceding or giving in to or consenting to write down. But again, too, with leases, you know, if the property is fundamental, if it is fundamental to the organisation going forward, again, too, it does need to be restructured, and potentially could be done in a very amicable way, which do agree. But it's just handy to know that the fallback position is there in terms of if it can't be, but ideally, yeah, if it can be dealt with in the process, all the better.
Yeah. Okay.
I suppose one thing popped up a bit there, and we scattered, is funding, Philip. You know, we've talked about writing down and the ability to write down, but ultimately, while there still has been a write down of debt, there still is funding required in order to implement a scheme and to make this whole thing possible. And I suppose just in terms of sources of funding, or how one might go about looking at that, might just
like as you said, it's key. Again, you said a number of things is key to this process, but without funding available, then it's unlikely that the scheme is going to be successful, as you said, because creditors want to see some level of payment on conclusion of the process. So again, what's in it for them? So there is funding available. Typically, and there are funders in the market as well. But typically what we have seen so far is that, and I think this is the kind of the general view that's come back, David, is that most of the schemes we have been involved with, there's an equity injection as opposed to debt, and typically it comes from a related party or even the existing shareholders. So outside of that, which will be the first port of call, you know, you are looking at the likes of the invoice discounting. You know, there may well be existing invoice discounting in place. Source funding again is another aspect of it. So, and look, you potentially be looking at existing lenders and creditors, but I suppose that the fear would be that because you're going through this process, there's going to be a concern as to whether you'll be able to trade through it and come out the other side. So there's going to be a reluctance from from lenders, I should say, you know, to provide that finance going forward. So again, it's really back to the key point that early engagement is key, because if and planning is important, because if you know where you stand in terms of the funding and that it's available, that's a big driver in the process as well, because that will be your I guess your carrot that you'll dangle at the creditors to say, look, you know, this is available for you, and also for revenue as well, back to revenue and excludable creditors who are very keen at an early stage to understand the extent of the dividend. And you know, they wouldn't be shy as well in I suppose negotiating that to a better position. So there's always an element of negotiation there, and again that's something that your process advisor can manage and assist you on. But without the source of funding available, then you can't really do it. So that gives you kind of a bit of an overview as to the funding sources. It's a critical ingredient in the process.
Yeah, and again, I know I'm banging on about it, but that for me again is back to the early engagement piece, because you know, having done the projections and stuff and looked at what the funding requirement is, then you can go and, as you said there, look at the different sources and see who's willing to do it. Again, too, you get this blanket some the banks are closed. No, they're not. And there's plenty of other sources outside the traditional lenders in the market, and Philip outlined, be it invoice discounting or asset finance or whatever. So it's a bit like, well, there's a will, there's a way. And again, to come back to the early engagement piece, if there's a viable business here, it makes sense to do it. You'll find somebody to fund whatever might be required. I suppose we find quite a lot that, again, to I suppose an advantage, if you like, in relation to SCARP, that it's the existing principals stroke shareholders are usually ones that come up with the funding, and by doing so, then they stay in control of the entity going forward. We're using examinership. It's open to others to come on board, and very often there can be the risk of control there from the point of view of the principals and stuff like that. But under SCARP, it's usually existing principals that come up with the funding.
Yeah.
You know.
There's a question that's come in there, which is pertinent because it refers to I suppose the process in engaging with the court locally. And the question is, if a creditor objects to a rescue plan, how does the PA decide on which court is relevant? So that is set at the start, whereby the registered office of the company, it'll be the circuit court that's most, I suppose, closely located to that company, where the I suppose the original application and resolutions and documents for the appointment of the process advisor is lodged, and it's that court, be it I suppose the Tralee District Court or the Dublin Circuit Court, that will take jurisdiction of the case, I suppose. And really, once you will do that, the process advisor, the company will do that, and that sets I suppose the location of the court, and it's from there then when a creditor, if a creditor is going to object, they will go to that court and they will file their objection. So it's typically, just to answer the question, it's typically where the company carries out its main business.
Yeah, and in fairness, that's actually an interesting question, Philip, because I think there can be the perception out there that, the circuit court judges, with all due respect to them, don't have, the experience or knowledge to deal with a matter like this. I suppose what we found over the years, particularly for the last 10 years, with the introduction of the personal insolvency legislation, which is dealt with in the circuit court, they have become more familiar, let's call it, with insolvency generally. So I think there's less of a concern or worry about a circuit court judge not having the ability or knowledge, experience to deal with that. Whereas I suppose historically, particularly for us involved in examinerships, in terms of the High Court, the High Court judges, they're very familiar with the legislation and stuff like that. So therefore, they get through things much quicker. But I just think as time goes on in the Circuit Court, it's less of a concern or an issue. And again, if for whatever reason, it's like, oh no, we don't want to go to that Circuit Court, it has to be exceptional circumstances as to why you wouldn't go to that court and want to go to the High Court, which again ties back into, we were talking about a solicitor earlier on. So, if it is a case that, a particular company is located and that they want to go to make the application, a particular circuit court judge for whatever reason, I think that's where, the legal advice comes in and stuff. And because it's very much like, if we're going to go to the High Court, well, we need to have exceptional solid grounds as to why we do that, as opposed to not going locally to the circuit court. But it is an interesting question. But I think as time goes on, I think it's a less concern. I think they're becoming more knowledgeable of insolvency generally and more comfortable in terms of dealing with it.
Yeah, okay. And maybe just a kind of an additional question around maybe the fees and costs and expenses of a SCARP. Just maybe your overall thoughts on that, David, because as we said, it's meant to be less costly than the examination process. It's meant to avoid the going to court. But I suppose the other side is that it is legislation driven. It is administrative heavy in terms of the notifications and the detail. I suppose that the engagement that's required with all stakeholders will be creditors and revenue in particular. So there is the flip side of it as well. So maybe just your overall thoughts in terms of what the fees, costs, expenses of a SCARP would be.
Yeah, I mean, at the end of the day, the process advisor needs to get paid, okay? And I suppose, again, the alternative here is liquidation. In a liquidation, the liquidator also needs to get paid. So there are professional fees involved, and everybody needs to be fully aware and appreciate that, okay? Because like you said there, in terms of the process itself, like, while, it's envisaged to be over a 7-week, 49-day period, an awful lot has to happen in that. But there's a lot of work that has to happen before the process itself. So that also should be borne in mind. Now, I think, and the legislation provides that, it is envisaged that, it is to be less costly. So therefore, it's envisaged that the process advisor would use, the company's staff in terms of helping him or her, in terms of the process advisor, carry out their duties and work like that, as opposed to maybe relying solely on their own staff. Again, looking at the complexity of the case, the matters they had to deal with, how effective the process advisor was in terms of the administration of the SCARP itself, looking at the nature and value of the company's assets and all that sort of good stuff. So I'm not going to mention a number, because I don't want people going off around saying, oh, today in a call, David Swinburne, this is the cost of a SCARP, because it would be unfair of me to do that, because as we all know, each case is very much different. But I think it must be appreciated for SCARP to be successful. There are professional fees. The process advisor does have to get paid, because he or she does have to do a very professional, proficient job in a very short time frame, and needs to have the experience and skills to do that, to negotiate with all the different creditors in conjunction with the company to ensure that the SCARP actually works. And again, too, so the alternative here is liquidation. So in a liquidation, a liquidator also gets paid, but then they'll be left with the creditors. But so yeah, no, it's just there are professional fees due, and it's important just to bear that in mind. And in terms of the early engagement piece and looking at the projections and the cost and the funding, that also needs to be factored into it. But in overall terms, again, too, because we're not going to be necessarily going to court and stuff like that, the professional advisors around the process advisor, that the fees for those should be lower. So in overall terms, the costs and expenses of the process are envisaged that there would be much less than if he would be in examinership, because an examiner, the examiner has his or her legal team as well, as does the company and stuff like that. So it gets more complex and convoluted, and the costs, because there's more people involved, But I think just to be borne in mind, yes, that there are professional fees due, and rightly due. I think might sort of answer the question. Maybe people might be looking for a number, but I don't have one.
No, that's fine. I know, I suppose we mentioned about the process, so it might be useful just to spend a minute on giving an outline. Now, I know separately, David, I think you said you were going to share some slides which might well have that illustrated as well. But the way I see the process is in terms of a kind of a two-stage approach. The first stage is really to once you've engaged with the company and the stakeholders, it's to have that statement of affairs prepared as well, but to prepare a process advisor's report. And to me, that's the culmination of all that work of meeting creditors, early engagement, and understanding that this business has a reasonable prospect of survival. That's the process advisor's report, and that's the report then that gets circulated to creditors, stakeholders, and that sets out the I suppose the clear path for the company to navigate through, and what is the what is the plan for the company. And then the second element to it is really around the rescue process. So that would involve engaging with the creditors directly and corresponding with creditor stakeholders, and really formulating the plan on foot of the funding that's available, getting everybody's confirmation of debt, and putting together a scheme which is acceptable, and holding the relevant meetings to verify and confirm those scheme payments and that plan. So that's the second aspect of it, and really that should lead then to the approval of the rescue plan. So it's a two-stage process, the process advisor report being number one, and then number two is the rescue plan, I suppose, again in writing and in detail, and in answer to the legislation as well, making sure that all points are covered off, which will, with everything that we've said, will lead to the approval of the rescue plan.
Yeah, and an awful lot has to happen in that short time frame as well. I suppose just there are lots of steps, you know, to get to within the 49 days to get it before the creditors to vote, you know. And again, too, talking about creditors, you know, you want to have creditors, you'll have them in different classes, but you want to have creditors of like interest in the same class. And at the end of the day, you know, you need at least one class of creditor to accept the scheme that's put before them. And in order to do that, you know, you need 60% in number representing the majority in value of that class voting in favour of the scheme. And if you do have one class of creditor voting in favour, that's enough to get it across the line. That's not to say that a creditor class who may not have voted in favour of it, if they're still not happy with that, because it is binding on them, so other class vote in favour of it, like they can go to court. So they have 21 days from the scheme, if you like, being finalised, if you like, to appeal and make an application to court for that, like, so 21 days, you know, so then your 49 plus 21 is up to 70. So, you know, you're not out of the woods, if you like, until 70 days, you know. But again, too, I think from the engagement during the SCARP process, you know, whether or not creditors are likely to object to it. And I suppose in terms of working with them throughout the process, if there is issues there, you can work through and maybe rejig the scheme to make it work for them, you know, but they can object to it, a creditor. If the scheme has been passed by one class and there is another class that are not happy with it, a creditor or creditors in that class could go to court, you know, and you know, whatever, make an objection to the scheme, you know. So just to bear that in mind, you know.
Yeah. Okay. Look, we still have a few minutes for any other questions that people want to pose. I suppose one of the overriding principles in it, David, is, and I think you may have mentioned this at the outset, is that you want to maintain the value of the asset. It's the thrust of the legislation is to protect companies that are fundamentally viable, that may have gone through an event such as COVID and had an impact. But you want to maintain the value of the asset, protect that in as much as possible, and really to right size the balance sheet and to write down the liability of the company, so that it's you know, it's in a stronger position after the process than it was before it, and really that's the selling point for accountants out there who are dealing in practice with their clients, you know, that there is a viable option and it is a useful restructuring tool for fundamentally sound businesses.
Yeah. And that's fundamentally it. Yeah, you want to keep the assets, the value up there, be it tangible assets or intangible, and the bit below, which is making the company insolvent, you want to write that down to a level so in overall terms the balance sheet is solvent going forward, and that's the key thing. A question just popped in there. Would you, I don't know if that's me or you, Philip, or both of us, agree that 75% of professional work and fees should be done prior to the PA, except in the public aspect of the role? And if I'm being honest, yes, absolutely, because the work, because again, us professionals that are working in this space know that just you can't start the process, you know, and within 49 days you're going to be out, you know. So absolutely 75% of the professional work, I would agree, that is done. And that's come back to me harping on about the early engagement point, because in practice, or in practical terms, an insolvency practitioner will not start the clock in terms of the formal SCARP process unless he or she knows that it does have the reasonable prospect of survival and success. And in order to do that, or to determine that, 75%, I would agree, of the work would need to be done before that. And if you have that done, stuff inevitably will come up within the SCARP process, but you have the time and the headspace to deal with that, because, you know, a lot of preparatory work will be done. So yes, I would agree that a lot of the work is done prior to the formal SCARP clock ticking, if you like. And it would need to be, because, you know, within 49 days you need to be done. And within that, if we just touched on there, there's a lot of little milestones along the way that need to be met, you know, and you need to be done by day 49, and you have to give the creditors at least 7 days notice. So by day 42, you have to have the scheme done. You know, that's very short. So yes, it's a very good question, and I like that. Yeah, that the majority of the work done is before you. And that comes back to the whole.
Probably one of the last questions that have come through is in terms of the excludable creditors. Do they vote on the scheme even if their debt is protected? So that depends. I suppose it's the excludable creditor. Just to I suppose restate is that they have the ability not to participate in the process. So if they decide that they're not going to participate in the process, well then they're outside of the process. Their debt is outside, and there's a decision to be made as to whether you continue on with the remaining debt, and whether that could still provide a kind of a kind of a successful conclusion. If the revenue decide then that they want to be part of the process and they'll opt in, that means that they can still decide that they vote against the scheme, but it's obviously much more likely that if they have opted into the scheme that they're going to go with the scheme. As I said earlier, what revenue will do is will seek, I suppose, at an early stage to understand what the expected dividends are likely to be. So if I hope I'm making myself clear now, but if the excludable creditors decide that they're inside the process, then they'll typically vote on the scheme.
Yeah, that's exactly it. And I suppose the thing is, if they're outside the scheme, you know, and they're fundamental, which are nominal revenue, well, if the overall scheme what you're trying to do there won't work, so therefore you want them in. So therefore, if they are out and staying out, they need to be resolved outside the scheme, and if they can't be, well, then potentially the overall scheme will collapse because they're not being dealt with within the scheme, you know. Another question just popped in there in relation, does the 49 days relate to working business days, or no, it's calendar days. So again, which is 7 weeks, but for, you know, so yeah, you paired that back to working days. So again, it reiterates the point of that the question somebody else raised about the majority of the work done before that. No, it's 49 calendar days. So which is even shorter.
It does go quickly through the process. Absolutely. Yeah.
Okay. I think there's no more questions there, but again, if anybody, they can pop them in. Again, if anybody wants to reach out to us afterwards via Laura, Michelle, or come directly to us, we'd be happy to talk to them. And you did allude, Philip. Yeah, we have a couple of slides which summarizes the whole process and what we touched on. So we'll send those out to Laura, Michelle, and she can circulate to all participants today. So yeah, thank you very much for everybody for the time and for the questions and the engagement.
Yeah,
thank you, David and Philip, for your insights and your time this morning. I think that was very useful. We certainly all got an awful lot out of it. You know, SCARP is still very new, and we'll absolutely be keeping you know, a keen eye on it over the next couple of months and years as well, I'm sure. So, you know, as David said, please feel free to reach out to ourselves or to David or to Philip as well. Have a look on our technical hub for our SCARP webpage as well. And thank you again to Chris, who's working away in the background and who swiftly sorted out my technical issues at the start as well. So thank you very much to everybody for attending, and thanks again to David and Philip.
Cheers. Thank you. Take care, everybody.